During the Civil War, Britain was funding both sides of the war. When the Confederacy fell, Britain conspired with the Union to erect a new form of control on American lands. In exchange for the states to pay off their Civil War debt by the 1870s, the U.S. incorporated itself and created a new Constitution with the Naturalization Act. In 1933, the U.S. government failed to pay off the war debt back to Britain and declared bankruptcy, leaving Roosevelt to unlawfully to call in all gold from citizens. Know the history of the system. In 1965, President Johnson signed the Coinage Act of 1965. The Coinage Act of 1965 changed the definition of what constitutes a dollar. Since October 1977, there can be no requirement of payment in legal tender but only in repayment of equivalent kind, negotiable instrument. From then on, all state governors pledged all the property of the people to the states, and all property ownership is in the hands of the state until you choose to take control it. A negotiable instrument is a document guaranteeing the payment of a specific amount of money, either on demand or at a set time, with the payer usually named on the document. When a buyer sends someone a promissory note and they accept it, they now become the holder, in due course liable for carrying out the order on demand. Lei greater than Wex. Negotiable instruments are mainly governed by state statutory law. Every state has adopted Article 3 of the Uniform Commercial Code (UCC) with some modifications as the law governing negotiable instruments. The UCC to NES, a negotiable instrument, is an unconditioned writing that promises or orders the payment of a XED amount of money. Drafts and notes are the two categories of instruments. A draft is an instrument that orders a payment to be made. An example is a check. A note is an instrument that promises that a payment will be made. Certificates of deposit (CDs) are notes. Drafts and notes are commonly used in business transactions to finance the movement of goods and to secure and distribute loans. To be considered negotiable, an instrument must meet the requirements stated in Article 3. Negotiable instruments do not include money, payment orders governed by Article 4A, fund transfers, or to securities governed by Article 8, investment securities. The rule of derivative title, which is applicable in most areas of the law, does not allow a property owner to transfer rights in a piece of property greater than his own. If an instrument is negotiable, this rule is suspended. A good faith purchaser, who does not have any knowledge of a defect in the title or claims against it, takes title to the instrument free of any defects or claims. In relation to the suspension of the rule of derivative title, Article 3 provides for warranties to protect the parties in transactions involving negotiable instruments. Checks are negotiable instruments but are mainly covered by Article 4 of the UCC. See also banking law. Secured transactions may contain negotiable instruments but are predominantly covered by Article 9 of the UCC. See also secured transactions. If there is a con-ICT between the articles of the UCC, both Article 4 and 9 govern over Article 3. The United Nations Convention on International Bills of Exchange and International Promissory Notes would preempt Article 3 in the case of international transactions if the United States were to join. As of early 2023, the U.S. signed but did not ratify the treaty. Greater than negotiable instruments. Negotiable instruments. Guidepost. https://www.law.cornell.edu/wex/negotiable_instruments #:text equals %20 UCC %20 defines %20 %20 negotiable, and %20 example %20 is %20 %20 check. Lei greater than Wex. A holder in due course is any person who receives or holds a negotiable instrument such as a check or promissory note in good faith and in exchange for value, without any notice or suspicion that it is overdue or was previously dishonored. Such a holder is entitled to payment by the creator of that negotiable instrument. Last updated in March of 2022 by the Wex Denitions team, Wex Commerce Commercial Activities Accounting Banking Business Law Business Organizations Property and Real Estate Law Business Sectors Commercial Transactions Property Law Wex Denitions. Greater than holder in due course. Holder in due course. Guidepost. https://www.law.cornell.edu/wex/holder_in_due_course #. tilde, text equals a %20 holder %20 inches %20 due %20 course, overdue. %20 or %20 was %20 previously %20 dishonored. Types of negotiable instruments. 1. Check. 2. Promissory note. 3. Bill of exchange. 4. Bank draft. 5. Certificate of deposit. 6. Money order. Google for more overstanding. Discharging instruments. In order to discharge, you will need to send a negotiable instrument into the Treasury and the creditor when you perfect the estate planning process and become a secured creditor. The Treasury will act as your banker and discharge debts on behalf of your bonded agreement with the USA via the birth certificate. Remember, there is no real gold to back our money, lawfully, and negotiable instruments must be used in exchange. Take note, if you send someone an obligation negotiable instrument and they don't respond within a certain frame, they have become the holder in due course, and must give you your remedy. U.S. Code Notes. Lee greater than U.S. Code greater than Title 31 greater than Subtitle 3 greater than Chapter 31 greater than Subchapter I. To provide the people of the United States with an opportunity to make gifts to the United States government to be used to reduce the public debt. 1. The Secretary of the Treasury may accept for the government a gift of A. Money made only on the condition that it be used to reduce the public debt. B. An obligation of the government included in the public debt made only on the condition that the obligation be cancelled and retired and not reissued, and C. Other intangible personal property made only on the condition that the property is sold and the proceeds from the sale used to reduce the public title. Section. Greater than Section 3113. Quick search by citation. Go. Section. Enter Title 31 U.S. Code Section 3113 Accepting gifts. 2. If the gift or transfer to the government is subject to a gift or inheritance tax, the Secretary shall pay the tax out of the proceeds of redemption. Pub. L. 97-258, September 13, 1982, 96 Stat. 943. The Secretary shall redeem a direct obligation of the government bearing interest or sold on a discount basis on receiving it when the obligation A. is given to the government, B. becomes the property of the government under the conditions of a trust, or C. is payable on the death of the owner to the government or to an OCER of the government in the OCER's OCL capacity. Debt, and 2. The Administrator of General Services may accept for the government a gift of tangible property made only on the condition that it be sold and the proceeds from the sale be used to reduce the public debt. B. The Secretary and the Administrator each may reject a gift under this section when the rejection is in the interest of the government. C. The Secretary and the Administrator shall convert a gift either of them accepts under subsection 1c or 2 of this section to money on the best terms available. If a gift accepted under subsection of this section is subject to a gift or inheritance tax, the Secretary or the Administrator may pay the tax out of the proceeds of the gift or the proceeds of the redemption or sale of the gift. D. The Treasury has an account into which money received as gifts and proceeds from the sale or redemption of gifts under this section shall be deposited. The Secretary shall use the money in the account to pay at maturity, or to redeem or buy before maturity, an obligation of the government included in the public debt. An obligation of the government that is paid, redeemed, or bought with money from the account shall be cancelled and retired and may not be reissued. Money deposited in the account is appropriated and may be expended to carry out this section. E1. Attention. Copy of this form is provided for informational purposes only. Copy appears in red, similar to the official IRS form. The official printed version of Copy A of this IRS form is scannable, but the online version of it, printed from this website, is not. Do not print and file copy A downloaded from this website. A penalty may be imposed for filing with the IRS information return forms that can't be scanned. See Part O in the current general instructions for certain information returns, available at www.irs.gov/form1099, for more information about penalties. Please note that Copy B and other copies of this form, which appear in black, may be downloaded and printed and used to satisfy the requirement to provide the information to the recipient. To order official IRS information returns, which include a scannable copy A for filing with the IRS and all other applicable copies of the form, visit www.irs.gov/orderforms. Click on Employer and Information Returns, and we'll mail you the forms you request and their instructions, as well as any publications you may order. Information returns may also be filed electronically using the IRS Filing Information Returns. Electronically fire system, visit www.irs.gov/fire closing parenthesis or the IRS Affordable Care Act Information Returns AIR program, visit www.irs.gov/AIR closing parenthesis. See IRS Publications 1141, 1167, and 1179 for more information about printing these tax forms. 8080. Form. Lender's TIN. Borrower's name. Rev. 1 2022. Street address including apartment no. Account number. See instructions. Borrower's TIN. CAT. No 14412G. City or town, state or province, country, and zip or foreign postal code. Lender's name, street address, city or town, state or province, country, zip or foreign postal code, and telephone no. www.irs.gov/form1099A. 1 Date of lender's acquisition or knowledge of abandonment. 2 Balance of principal outstanding. OM No 1545-0877. Form 1099A. Rev. January 2022. For calendar year. 5 Check if the borrower was personally liable for repayment of the debt. Play button. 6 Description of property. 4 Fair market value of property. Department of the Treasury, Internal Revenue Service. Acquisition or abandonment of secured property. 1099A. Copy A. 4. Internal Revenue Service Center. File with Form 1096. For Privacy Act and Paperwork Reduction Act notice, see the current general instructions for certain information. Returns. 20. Void corrected. $3. Do not cut or separate forms on this page. Do not cut or separate forms on this page. It comes with 3 copies. You must order your forms from the IRS. Because they scan the red copy. If you do not, you will be penalized. I ordered my 1099A, B, C, 1096, 1040V, etc. United States Treasury. 123456789 123456897 the 11th of November 2023 5000 $35,000 car payment Audi Automotive 95,764,684,476 X Instructions for borrower. Certain lenders who acquire an interest in property that was security for a loan or who have reason to know that such property has been abandoned must provide you with this statement. You may have reportable income or loss because of such acquisition or abandonment. Gain or loss from an acquisition is generally measured by the difference between your adjusted basis in the property and the amount of your debt cancelled in exchange for the property or, if greater, the sale proceeds. If you abandon the property, you may have income from the discharge of indebtedness in the amount of the unpaid balance of your cancelled debt. The tax consequences of abandoning property depend on whether or not you were personally liable for the debt. Losses on acquisitions or abandonments of property held for personal use are not deductible. See Pub. 4681 for information about your tax consequences. Property means any real property, such as a personal residence, any intangible property, and tangible personal property that is held for investment or used in a trade or business. If you borrowed money on this property with someone else, each of you should receive this statement. Borrower's Taxpayer Identification Number (TIN). For your protection, this form may show only the last 4 digits of your TIN, Social Security Number (SSN), Individual Taxpayer Identification Number (ITIN), Adoption Taxpayer Identification Number (ATIN), or Employer Identification Number (EIN). However, the issuer has reported your complete TIN to the IRS. Account number may show an account or other unique number the lender assigned to distinguish your account. Box 1. For a lender's acquisition of property that was security for a loan, the date shown is generally the earlier of the date title was transferred to the lender, or the date possession and the burdens and benefits of ownership were transferred to the lender. This may be the date of a foreclosure or execution sale or the date your right of redemption or objection expired. For an abandonment, the date shown is the date on which the lender first knew or had reason to know that the property was abandoned or the date of a foreclosure, execution, or similar sale. Box 2 shows the debt principal only owed to the lender on the loan when the interest in the property was acquired by the lender or on the date the lender first knew or had reason to know that the property was abandoned. Box 3 reserved for future use. Box 4 shows the fair market value of the property. If the amount in Box 4 is less than the amount in Box 2, and your debt is cancelled, you may have cancellation of debt income. If the property was your main home, see Pub. 523 to figure any taxable gain or ordinary income. Box 5 shows whether you were personally liable for repayment of the debt when the debt was created or, if modified, when it was last modified. Box 6 shows the description of the property acquired by the lender or abandoned by you. If CCC is shown, the form indicates the amount of any Commodity Credit Corporation loan outstanding when you forfeited your commodity. Future developments. For the latest information about developments related to Form 1099-A and its instructions, such as legislation enacted after they were published, go to www.irs.gov/form1099A. Free File Program. Go to www.irs.gov/freefile to see if you qualify for no-cost online federal tax preparation, e-filing, and direct deposit or payment options. Instructions for lender. To complete Form 1099-A, use the current general instructions for certain information, returns, and the current instructions for Forms 1099-A and 1099-C. To order these instructions and additional forms, go to www.irs.gov/employerforms. Caution: because paper forms are scanned during processing, you cannot file certain forms 1096, 1097, 1098, 1099, 3921, or 5498 that you print from the IRS website. Filing and furnishing. For filing and furnishing instructions, including due dates, and to request filing or furnishing extensions, see the current general instructions for certain information returns. Attention filers of Form 1096. This form is provided for informational purposes only. It appears in red, similar to the official IRS form. The official printed version of this IRS form is scannable, but a copy, printed from this website, is not. Do not print and file a Form 1096 downloaded from this website. A penalty may be imposed for filing with the IRS information return forms that can't be scanned. See Part O in the current general instructions for certain information returns, available at www.irs.gov/form1099 for more information about penalties. To order official IRS information returns, which include a scannable Form 1096 for filing with the IRS, visit www.irs.gov/orderforms. Click on Employer and Information Returns, and we'll mail you the forms you request and their instructions, as well as any publications you may order. Information returns may also be filed electronically. To file electronically, you must have software, or a service provider, that will create the file in the proper format. More information can be found at IRS Filing Information Returns Electronically FIRE System. Visit www.irs.gov/FIRE closing parenthesis, or IRS Affordable Care Act Information Returns AIR Program. Visit www.irs.gov/AIR closing parenthesis. See IRS Publications 1141, 1167, and 1179 for more information about printing these tax forms. Do not staple. 6969. Email address. Form Department of the Treasury Internal Revenue Service Filer's name. Name of person to contact. Employer identification number. Street address including room or suite number. Social Security number. city or town, state or province, country, and zip or foreign postal code. Enter an X in only one box below to indicate the type of form being filed. Fax number, telephone number, total number of forms federal income tax withheld. Alabama, Arizona, Arkansas, Delaware, Florida, Georgia, Kentucky, Maine, Massachusetts, Mississippi, New Hampshire, New Jersey, New Mexico, New York, North Carolina, Ohio, Texas, Vermont, Virginia. Form, Internal Revenue Service, P.O. Box 149,213 Austin, TX 78714-9213. OMNO 1545-0108. Total amount reported with this Form 1096. Under penalties of perjury, I declare that I have examined this return and accompanying documents and, to the best of my knowledge and belief, they are true, correct, and complete. 2023. 1096-2023. Annual Summary and Transmittal of U.S. Information Returns. For official use only. 1, 6, 2, 3, 4, 5. $. 5498 SA27. W2G1097 BTC 3250 109881 1098 C78 1098 E84 1098 F03. 1099 LS 1099 LTC 1099 MISC 1099 NEC 1099 OID 1099 PATER 169395719697. 1098 Q74 1098 T83 1099 A80. 1099 Q 1099 QA 1099 R31 1A98. 1099 B79 1099 C 1099 CAP 8573. 1099 S 1099 SOT 1099 SB75 9443 392125. 1099 DIV 91. 3922-26. 1099 G1099 INT 8692. 5498 ISA 5498 COT 28722A. 1099 K10. Instructions. Return this entire page to the Internal Revenue Service. Photocopies are not acceptable. Send this form, with the copies of the form checked in Box 6, to the IRS in a flat mailer not folded. 1096. Signature. For more information in the Privacy Act and Paperwork Reduction Act notice, see the 2023 General Instructions for Certain Information Returns. Title: When to file. Date: if your principal business, office or agency, or legal residence in the case of an individual, is located in. Use the following address. Future developments. For the latest information about developments related to Form 1096, such as legislation enacted after it was published, go to www.irs.gov/form1096. Reminder: you may be required to electronically file e-file information returns. Go to www.irs.gov/inforeturn for e-file options. Also, see Part F in the 2023 General Instructions for Certain Information Returns. Purpose of form. Use this form to transmit paper forms 1097, 1098, 1099, 3921, 3922, 5498, and W2G to the IRS. Caution: Form 5498 CA can be filed on paper only, regardless of the number of returns. Who must file? Any person or entity who files any form checked in Box 6 above must file Form 1096 to transmit those forms to the IRS. Caution: your name and taxpayer identification number (TIN), employer identification number (IN), or social security number (SSN) must match the name and TIN used on your 94X series tax returns, or you may be subject to information return penalties. Do not use the name and/or TIN of your paying agent or service bureau. Enter the filer's name, address including room, suite, or other unit number, and TIN in the spaces provided on the form. The name, address, and TIN of the filer on this form must be the same as those you enter in the upper left area of Form 1097, 1098, 1099, 3921, 3922, 5498, or W2G. Alaska, Colorado, Hawaii, Idaho, Illinois, Indiana, Iowa, Kansas, Michigan, Minnesota, Missouri, Montana, Nebraska, Nevada, North Dakota, Oklahoma, Oregon, South Carolina, South Dakota, Tennessee, Utah, Washington, Wisconsin, Wyoming. Internal Revenue Service Center, P.O. Box 219,256 Kansas City, MO 64121-9256. With Forms 1097, 1098, 1099, 3921, 3922, or W2G, file by February 28. With Forms 1099 NEC, file by January 31. With Forms 5498, file by May 31. Leap years do not impact the due date. See Announcement 91 to 179, 1991-49 IRB 78, for more information. Send all information returns filed on paper with Form 1096 to the following. If any date shown falls on a Saturday, Sunday, or legal holiday in the District of Columbia or where the return is to be filed, the due date is the next business day. File Form 1096 in the calendar year following the year for which the information is being reported, as follows. Where to file? Cat. No 144000. Estate number. XX. 10. Form 1096 2023 page. California, Connecticut, District of Columbia, Louisiana, Internal Revenue Service Center Maryland, Pennsylvania, 1973 North Rulin White Boulevard. Rhode Island, West Virginia Ogden, UT 84201. If your legal residence or principal place of business is outside the United States, file with the Internal Revenue Service, P.O. Box 149213, Austin, TX 78714-9213. Transmitting to the IRS. Group the forms by form number and transmit each group with a separate Form 1096. For example, if you must file both Forms 1098 and 1099A, complete one Form 1096 to transmit your Forms 1098 and another Form 1096 to transmit your Forms 1099A. Do not send a Form 1099, 5498, etc. containing summary, subtotal information with Form 1096. Summary information for the group of forms being sent is entered only in boxes 3, 4, and 5 of Form 1096. Corrected returns. Originals and corrections of the same type of return can be submitted using one Form 1096. For information about filing corrections, see the 2023 General Instructions for certain information returns. Box 1 or 2. Enter your TIN in either Box 1 or 2, not both. Sole proprietors and all others must enter their EIN in Box 1. Individuals not in a trade or business must enter their SSN in Box 2. However, sole proprietors who do not have an EIN must enter their SSN in Box 2. Use the same EIN or SSN on Form 1096 that you use on Form 1097, 1098, 1099, 3921, 3922, 5498, or W2G. Box 3. Enter the number of forms you are transmitting with this Form 1096. Do not include blank or voided forms or the Form 1096 in your total. Enter the number of correctly completed forms, not the number of pages, being transmitted. For example, if you send one page of 3 2A page Forms 1098E with a Form 1096 and you have correctly completed 2 Forms 1098E on that page, enter 2 in Box 3 of Form 1096. Box 4. Enter the total federal income tax withheld shown on the forms being transmitted with this Form 1096. Box 5. No entry is required if you are filing Form 1098T, 1099A, or 1099G. For all other forms in the listing that follows, enter the total of the amounts from the specific boxes identified for each form. Online fillable forms. Forms 1097 BTC, 1098C, 1098MA, 1098Q, 1099 Cap, 1099 Lieutenant Colonel, 1099Q, 1099 QA, 1099 SAW, 3922, 5498 ISA, and 5498 SA have been converted to online fillable PDFs. For more information, see online fillable forms in the 2023 General Instructions for Certain Information Returns. Form W2G, Form 1097 BTC, Form 1098, Form 1098C, Form 1098E, Form 1098F. Box 1, Box 1, Boxes 1 and 6, Box 4C, Box 1, Box 1. Form 1098Q, Form 1099B, Form 1099C. Form 1099 Cap, Form 1099 DIV, Form 1099 INT, Form 1099K. Form 1099 LS, Form 1099 Lieutenant Colonel, Form 1099 MISC. Form 1099 NEC, Form 1099 OID, Form 1099 PATR, Form 1099Q. Form 1099 QA, Form 1099 R, Form 1099 S. Form 1099 SA, Form 1099 SB, Form 3921, Form 3922, Form 5498. Form 5498 ISA, Form 5498 CA. Form 5498 SA2. Box 4, Boxes 1D and 13, Box 2, Box 2, Boxes 1A, 2A, 3, 9, 10, and 12, Boxes 1, 3, 8, 10, 11, and 13, Box 1A, Box 1, Boxes 1 and 2, Boxes 1, 2, 3, 5, 6, 8, 9, 10, 11, and 14, Box 1, Boxes 1, 2, 5, 6, and 8, Boxes 1, 2, 3, and 5, Box 1. Box 1, Box 1, Box 2. Box 1, Boxes 1 and 2, Boxes 3 and 4, Boxes 3, 4, and 5, Boxes 1, 2, 3, 4, 5, 8, 9, 10, 12B, 13A, and 14A, Boxes 1 and 2, Boxes 1 and 2, Box 1. FS Form 233 supersedes SF 233, Jan 1976, Department of the Treasury, Bureau of the Fiscal Service. Page 1 of 2, November 2021. Special power of attorney by individual for the collection of checks drawn on the United States Treasury. Witness the signature of the undersigned, this, blank, day of, blank, 20 ______. Impress seal here, blank, blank. Witness my signature, official designation, and seal, blank, blank. Initial the appropriate line. If the grantor fails to initial in front of any option, A shall be presumed. Blank, A. This power of attorney shall automatically be revoked upon a determination that I, the grantor, am incompetent. Blank, B. This power of attorney shall remain effective to the extent authorized by 31 CFR Part 240 following a determination that I, the grantor, am incompetent. Blank, C. This power of attorney shall become effective upon a determination that I, the grantor, am incompetent, and shall remain effective to the extent authorized by 31 CFR Part 240. Know all by these presents, that the undersigned, blank, blank, of, blank, blank, address does hereby appoint, blank, blank, of, blank, blank, address, as his/her attorney to receive, endorse, and collect checks payable to the order of the undersigned, drawn on the United States Treasury and issued for, blank, blank. Purpose for which checks are issued and to give full discharge for the same, hereby ratifying and confirming all that said attorney shall lawfully do by virtue hereof. This power of attorney is not given to carry into effect an assignment to the attorney, or to any other person, of the right of the undersigned to receive the above described payments. See instructions on next page, paragraphs 3A and 3B. Signature of grantor. Official designation. Signature of attesting officer. Durability of this power of attorney. Dated at, blank, this, blank, day of, blank, 20, blank, my commission expires, blank, 20, blank. Important. Do not execute this instrument without first reading the instructions on the next page. Exact compliance with these instructions will avoid complications. Personally appeared before me the above named, blank, blank, known or proved to me to be the same person who executed the foregoing instrument, and acknowledged to me that he executed the same as his free act and deed. blank, underscore, blank, underscore, blank. First last 12 wake up lane last first. Reducing public debt. X. Guidepost. https://fiscal.treasury.gov/files/check-claims/form_233.pdf. FS Form 233 supersedes SF 233, Jan 1976 Department of the Treasury Bureau of the Fiscal Service. Page 2 of 2. November 2021. Special power of attorney by individual for the collection of checks drawn on the United States Treasury. Instructions for Fiscal Service Form 233 read carefully. See 31 CFR Part 240 for more information. 1. A power of attorney using this form may be executed as authority for the endorsement and collection of checks drawn on the United States Treasury for purposes other than those identified at 31 CFR 240.16b. This power of attorney must name the attorney-in-fact and must recite that it is not given to carry into effect an assignment to the attorney-in-fact, or to any other person, of the right to receive the payments therein described. 2. The grantor should explicitly indicate whether he/she intends the power of attorney to automatically revoke if the grantor is determined to be incompetent. B. The power of attorney to remain effective despite a determination that the grantor is incompetent to the extent authorized by 31 CFR Part 240, or c. The power of attorney to become effective only upon a determination that the grantor is incompetent and to remain effective as long as authorized by 31 CFR Part 240. If the grantor fails to clearly indicate his/her intent on the power of attorney, the power of attorney shall automatically revoke upon a determination that the grantor is incompetent. 3. Where desirable or where required by foreign, state or local law, this power of attorney should be acknowledged before a notary public or other officer authorized by law to administer oaths generally. If in a foreign country, the acknowledgement should be made before a United States diplomatic or consular representative. If such an officer is not available, it may be acknowledged before a notary or other officer authorized to administer oaths, but his official character and jurisdiction must be certified by a United States diplomatic or consular officer, under the seal of his office. 3b. Where the power of attorney is acknowledged pursuant to paragraph 4, the seal of the attesting officer must always be impressed or stamped, provided, however, that where acknowledgments before a notary public, or other officer authorized by law to administer oaths, are not thus authenticated by the official impression seal of such officer, the power should be accompanied by a certificate from the proper official showing that the officer was in commission on the date of the acknowledgement. The date when the officer's commission expires should appear in any event. If a certificate is furnished, such certificate should show the dates of the beginning and end expiration of the officer's commission, and such period of commission should include the date of acknowledgement of power. 3c. Notwithstanding the foregoing, persons subject to military jurisdiction may acknowledge powers of attorney before officers specially designated for that purpose pursuant to law. 4. This power of attorney is revoked by the death of the grantor and may also be revoked by notice from the grantor to the parties concerned. Notice of revocation to the Treasury will not ordinarily serve to revoke the power. 5. If it is desired that checks be mailed to the attorney instead of to the payee, formal notice of change in the post office address, identifying the checks affected, should be forwarded to the administrative office that authorized issuance of the checks. 6. Powers of attorney need not be filed within the United States Treasury. Power of attorney, motor vehicle only. Blank, the principal of blank, herewith appoints blank of blank as their attorney in fact, to act in the place and stead and with the same authority as principal would have to transfer the following motor vehicle, and to take any other necessary steps to transfer title the following motor vehicle, make, blank, model, blank, year, blank, body, blank, vehicle identification number, blank. Important. Federal regulations require this statement to be given to purchasers on sales of vehicles. An inaccurate or untrue statement may make you liable for damages to the buyer, and there may also be civil or criminal penalties. The odometer described above now reads, blank, miles. Certify one of the following, please, XXX, the appropriate line before the correct statement. Blank, we certify that to the best of my knowledge the odometer reading as stated above reflects the actual mileage of the vehicle described below. We certify that to the best of my knowledge the odometer reading as stated above reflects the amount of mileage in excess of designed mechanical limits of 99,999 miles of the vehicle described below. We certify that to the best of my knowledge the odometer reading as stated above is not the actual mileage of the vehicle described below, and should not be relied upon. Certify one of the following, please, XXX, the appropriate line before the correct statement. We certify that the odometer of the vehicle described above was not altered, set back, or disconnected while in my possession, and we have no knowledge of anyone else doing so. We certify that the odometer was altered for repair or replacement purposes while in my possession, and that the mileage registered on the repaired or replaced odometer is identical to that before such service. We certify that if the repaired or replacement odometer was incapable of registering the same mileage, that it was reset to 0, and that the mileage on the original odometer or the odometer before repair was miles. The sales price of the vehicle is $, and $$100. Google for full document. Send out your package, along with your authenticated birth certificate and discharge letter 3 times. Side note: just like you have 72 hours to respond to contracts, 3 months for your debt to be public, etc. First, formal notice, you have to put them on notice so they know what you're doing. We are dealing with contracts. Second, notice letter to cure, send a copy is a opportunity for them to fix their mistake. We all make mistakes. Third, put them in default for being in violation of UCC 9-203. Always have your law, code, statutes, etc. They want and need to see. Black and white, words are just presumption, hearsay, show the facts. Administrative process. LE greater than Uniform Commercial Code. A security interest attaches to collateral when it becomes enforceable against the debtor with respect to the collateral, unless an agreement expressly postpones the time of attachment. Except as otherwise provided in subsections C through I, a security interest is enforceable against the debtor and third parties with respect to the collateral only if 1. Value has been given. 2. The debtor has rights in the collateral or the power to transfer rights in the collateral to a secured party, and 3. One of the following conditions is met. A. The debtor has authenticated a security agreement that provides a description of the collateral and, if the security interest covers timber to be cut, a description of the land concerned. B. The collateral is not a certificated security and is in the possession of the secured party under Section 9-313 pursuant to the debtor's security agreement. A. Attachment. B. Enforceability. Greater than Section 9-203. ATTACHMENTAND. Enforceability of security interest, proceeds, supporting obligations, formal requisites. Section 9-203. Attachment and enforceability of security interest, proceeds, supporting obligations, formal requisites. Guidepost. https://www.law.cornell.edu/uk/9/9-203. Since they did not pay you back for your automobile, they have abandoned it on your private property. Take note to Texas Transportation Codes, Abandoned Motor Vehicles Section 683.0141, that a company's failure to pay off storage fees after 20 days waives all your rights and interests in the automobile. Go to Department of Revenue and do a title search on your car to get the record. Then go to the DMV and get an inspection report done. Afterwards, gift the car to your foreign trust to avoid the sales tax. Then apply for the car title on a car application. We want no liability. Reason: we operate using entities SS4 aka IN. Look up abandonment laws for your state. Look up your state's status. You can send it certified mail with green slip. Dealing with money: my understanding is use registered mail. Register mail # loan company date year address state, Texas zip code. Contract ACCT number *** 1234 contracting party, first last. This is an attempt to correct inaccurate information being reported in my credit report published by your company. Upon being denied credit due to information being published in my credit report, I found an item on the report that you are publishing which are inaccurate. The accounts in question are listed below. Loan company's name will be on your credit report number 0023456789. Unverified account. They never validate or verify alleged debt. I am demanding that you disclose all of the documents upon which you are relying on, for the reporting on account 1 and 2 above, collectively referred to as accounts. In accordance with your obligations under the Fair Credit Reporting Act 15 U.S.C. Section 1681 grams, the consumer is entitled to said records, the requested records. The information you are reporting is harming my reputation, it's adversely affecting my credit worthiness, and I am being denied credit as a result of this inaccurate reporting. Comes now, last, first middle creditor DBA first M last, for the estate on behalf of the interest in the first middle last, or any derivation of the name, as written in all communication concerning the obligation at hand. On the 11th of November 23, a final payment for the amount of the full contract was sent to your agency for full payoff of the balance of the vehicle. Your acceptance and receipt of the final payment dated the 11th of November 23 sent by check draft constitutes a final payment. A conspicuous statement to the effect this instrument was tendered as a final payment was written on the check. Pursuant to Texas UCC 3.310 effect of instrument on obligation for which taken, unless otherwise agreed, if a certified check, cashier's check, or teller's check is taken for an obligation, the obligation is discharged to the same extent discharge would result if an amount of money equal to the amount of the instrument were taken in payment of the obligation. Silence is acquiescence. Discharge of the obligation does not affect any liability that the obliger may have as an endorser of the instrument. B. Unless otherwise agreed and except as provided in subsection A. If a note or an uncertified check is taken for an obligation, the obligation is suspended to the same extent the obligation would be discharged if an amount of money equal to the amount of the instrument were taken. Take notice that your agency was given sufficient notice and an adequate amount of time to either send the payment back to the contracting party in the same manner it was sent or advise on where to properly send the payment. Once the payment was not sent back, your agency became the holder in due course of the instrument and is therefore liable for the discharge of the debt at hand. Pursuant to UCC 3.302, holder in due course. Subject to subsection C and section 3 to 160, holder in due course means the holder of an instrument if B. Notice of discharge of a party, other than discharge in an insolvency proceeding, is not notice of a defense under subsection A, but discharge is effective against a person who became a holder in due course with notice of the discharge. Public filing or recording of a document does not of itself constitute notice of a defense, claim in recoupment, or claim to the instrument. Take further notice that the estate of first middle last is now in possession of the real property vessel in his storage facility, as defined by Texas Transportation Codes, Chapter 683. Abandoned Motor Vehicles Code Section 683.0017. You have approximately 20 days from your receipt of this letter to pay the estate of first middle last the amount of $35,000 and pick up the motor vehicle, or the administrator of the contracting party's estate will file for an abandoned title releasing you from any responsibility or liability as a lien holder on the property altogether. Any property in question will be titled under the name current holder of the property. Take note to Texas Transportation Codes, Abandoned Motor Vehicles Section 683.0141 that your company's failure to pay off storage fees after 20 days waives all your rights and interests in the automobile, and consents first middle last as the garage keeper to sell off the item as an abandoned vehicle, pursuant to Texas Transportation Codes, Abandoned Motor Vehicles Section 683.031 1. Also take notice that in Texas Transportation Codes, Abandoned Motor Vehicles Section 683.0142(c) that states any person who purchases or is the owner of real property on which vehicles, vessels or watercraft, or outboard motors, have been abandoned, without the consent of said purchaser or owner of the real property, may apply to the Department of Revenue for a certificate of title. You have 20 days to settle this dispute. Take note that if you attempt to repossess or tow the automobile without first last's permission, you will be charged according to his fee schedule on public record for theft and illegal warehousing, in which first last will pursue his full legal remedy and lawsuit. And take further notice Title 18 Part 1 Chapter 31 Section 645. Whoever, being a United States Marshal, clerk, receiver, referee, trustee, or other officer of a United States court, or any deputy, assistant, or employee of any such officer, retains or converts to his own use or to the use of another or after demand by the party entitled thereto, unlawfully retains any money coming into his hands by virtue of his official relation, position or employment, is guilty of embezzlement and shall, where the offense is not otherwise punishable by enactment of Congress, be fined under this title or not more than double the value of the money so embezzled, whichever is greater, or imprisoned not more than 10 years, or both. But if the amount embezzled does not exceed $1,000, he shall be fined under this title or imprisoned not more than 1 year, or both. It shall not be a defense that the accused person had any interest in such moneys or fund. By jurat, subscribed and sworn to or affirmed before me on this day of year, by, proved to me on the basis of satisfactory evidence, to be the persons who appeared before me notary, seal, notary signature. You are going to need your presentment bill. It should be accepted and endorsed front and back with your stamps on it to give your presentment value. Affidavit of Walker Todd, affidavit of truth, the laws and codes to back up your claim, letter of advice, bonded bill of exchange. You should also have your UCC1 ad, and UCC3. As you will record this transaction as this is private banking. Remember, you must have your contract set up with the United States of America. This is on the private side as we are the original creditors. This process is not for the public debtors. Your process is different. Refer to my previous video. This is and will always be the process if you are operating as a debtor on the public side. What you will need. This is my inner and overstanding. This is not for educational purpose only. This is knowledge, but you must do your own due diligence. Never take what I say as par value, face value. This is commerce, not a get rich quick or get stuff for the free scheme. You operate utilizing your credit, then you have a right to discharge, offset your alleged debt. As we hold no obligation of the public debt according to 18 U.S.C. 8. They must give us a remedy or they are operating outside of the bankruptcy. That is a very big violation and they are violating every dang day. Hope you enjoyed.